Welcome to Level Table Live, Level Legal's monthly legal services live stream, where we dish out breaking news, hot tips, and personal stories. I'm Joey Seeber, CEO of Level Legal, and as usual, I have my co-host, Daniel Bonner.
Hey, Joey.
Our Director of Client Solutions.
Looking forward to this. This is going to be a fun one.
We're excited to have you here as we explore dropping dimes, Kelly Twigger on case law, generative AI, and other eDiscovery assists. By the end of our time, we'll cover what the FTC and SEC intensification of failure to preserve rules mean for legal professionals. Riveting topic. Why law schools are beginning to focus more on eDiscovery and how to leverage AI for the law in general. And we'll talk about eDiscovery too. Kelly, welcome to Level Table Live.
Thanks, Joey. Appreciate you being here. Thanks, Daniel. Thanks for having me.
We're very glad that you're here. We're introducing Kelly Twigger. For starters, she played basketball at Washington University, where she appeared in the Final Four.
Let's go.
That's where the dropping dimes comes from in the title. She's a graduate of Marquette University Law School. She worked in big law, so first she's an attorney. In 2009, she left to start ESI Attorneys, an eDiscovery consulting firm that is also a law firm. So Kelly's an entrepreneur. She co-authored Electronic Discovery and Records and Information Management Guide in 2011, still offered by West. She's a writer. The Wisconsin Bar named Kelly the Legal Innovator of the Year in 2014 for the development of eDiscovery Assistant, online eDiscovery playbook for lawyers and legal professionals. So she's a serial entrepreneur. For more than 2 years, she was a columnist for Above the Law, so finally a thought leader. And she lives in Boulder, Colorado, and follows Kentucky basketball. I'm sure there's more, Kelly. Welcome.
Thank
again.
you.
Glad you're here.
I think that's plenty.
So, Kelly, you've been in eDiscovery about as long as Level Legal's been in existence, 15 years. Tell us how you got here.
I've been practicing for 25 years. I started as a commercial litigator at Quarles & Brady in 2009. I had the benefit of, before starting at Quarles, having both clerked for a federal judge, worked at the in-house counsel at a major insurance organization, and working as a prosecutor for a year under the Wisconsin Supreme Court rules. We were allowed to work as a prosecutor in the Milwaukee County District Attorney's Office. So by the time I got to Quarles, I had a really good insight into the different ways in which law is practiced and the different implications of different areas of practice. And I was really fortunate to be at a terrific firm with a tremendous group of people. In 2004, I just really happened to attend the first ever ABA meeting on electronic discovery in New York City. It was a very small hotel room, not anything like what we see for eDiscovery conferences now. Maybe 20 people in the room, one of which was Judge Shinlin, who, as you probably know, was the author of the Zuba Lake decisions, which really formed the basis for the amendments to the Federal Rules of Civil Procedure that came out in 2006. And so that conference was the first discussion among professionals on electronic discovery. And I came back from that meeting and sat down with a bunch of folks at our firm and put together our group on electronic discovery and records and information management, which we called the Red Team at the time. And we had about 24 professionals from knowledge management, corporate litigation, and things, advising both our lawyers internally on what their obligations were going to be under the new federal rules and what our clients needed to be preparing for in order to mitigate risk for ESI related issues. And so that's really how I got started in that. I spent a lot of time learning, doing projects for clients, creating data maps, sitting down with a lot of IT people. I have a bit of background in computers. My first job ever was building clone computers at 18. I knew a little bit of the lingo, but I was never afraid to ask questions. And I would say in this space, that's kind of my number one piece of advice for anyone is don't be afraid to ask questions that you don't know the answers to. You know, what does this mean? How does that work? All those kinds of things. So that's pretty much how I got started in this particular space. And now my job is really to act as a litigation strategist, a discovery strategist for purposes of litigation. I was fortunate at Quarles to have a wide range of experience in that we represented Microsoft in indirect purchaser cases and Harley-Davidson in Beth Company class action matters. So worked on really small insurance matters and really huge $100 million cases. So it's a huge spectrum. It gave me an opportunity to really see a lot of what discovery looks like in small versus large matters and what kinds of considerations you have to have in the paper world, and then to be able to translate those into eDiscovery.